Hi, everyone. I'm Paul Coble, Chair of Intellectual Property and Artificial Intelligence at Rose Law Group. I'm here to talk to you about a recent development at the intersection of IP and artificial intelligence, specifically a new case out of the District of Massachusetts that deals with what types of features in artificial intelligence software can be protected by copyright law. If you've heard me talk about AI and copyright before, I've spoken a lot about the creative element of copyright and how for a work to be protected by copyright, it has to meet the minimum threshold of creativity. Specifically, as I've talked a lot about how the creative element works with generative AI, the focus has been recently how whether a human performs the creative elements of a work versus whether a non-human, such as artificial intelligence or an AI system, performs the creative elements. If a human performs the creative elements, then the work can be copyright protected. But if the creative aspects are performed by generative AI, for example, then the resulting output is not copyright protected. The case I want to talk to you today about also deals with the creativity element of copyright law, but instead analyzes the level of creativity that needs to be present in order for something to be protected by copyright law. It's generally said that the creative bar is very low in copyright, but it's not non-existent. There needs to be some minimum level of human creativity in order for a work to be protected by copyright. The case I want to talk to you about today is called Overjet versus Vidya Health. It comes out of the District of Massachusetts Federal Court and was recently the subject of an opinion on plaintiff Overjet's motion for preliminary injunction. If you're not familiar with preliminary injunction, is essentially when the plaintiff asks at the onset of a case for the court to institute an injunction or a ruling preventing or ordering the defendant to take some specific action or refrain from taking a specific action. In this case, the plaintiff wanted the court to order the defendant to not go to market with their AI-based software. The software issue here has to do with software for dental imaging, specifically to help dentists in the identification, treatment, diagnosis, and overall projection of dental diseases such as cavities. Both the plaintiff and the defendant have AI-based software that helps dentists identify these problem areas and highlight the problem areas on the dental imagery. Let me show you an example here of the two images that are at issue, so that you can see what we're talking about. Overjet, the plaintiff in the case, claims to be the first such company to be able to have a particular type of feature called segmentation. All other types of dental imaging software that have been approved by the FDA, according to Overjet's complaint, have to use a technology called bounded box technology. Essentially, the software overlay can only show a box around the problem area. If you've got a cavity, it puts a box and says the cavity is somewhere within this box, but does not highlight the specific contours of that cavity. Overjet's AI claims to be the first software that is FDA approved to use a process called segmentation, where they can actually overlay the contours of the problem area so that you can see the specific outline of, for example, the cavity. Overjet claims to be the first and only, as of the filing of this lawsuit, to be FDA approved to do the segmentation. Claims that everyone else has to rely on this bounded box technology, where they can just show a box and say the cavity is somewhere within this box. So it was a big surprise to Overjet, apparently, when they saw at a trade show that Vidya Health had come out with a similar overlay, marketed primarily, well, solely to patients. So it doesn't have much to do with the IP claims in this, but it does have, I think, quite a bit to do with the overall market impact that Vidya Health was marketing this overlay only as a patient view and not for clinicians to use in the diagnosis, treatment, or identification of oral health diseases. So regardless of that fact, I think that realistically, we all know that the feature would not, in practice, likely be used only by patients, but would also be to some extent relied on by clinicians. Nonetheless, the FDA approval is not the subject of this this lawsuit. Rather, Overjet brought claims alleging a variety of copyright infringement, as well as some unfair competition and false advertising. I'm going to focus solely on the copyright matters because I think that that's what's most unique in this case here. In evaluating whether Vidya had infringed upon Overjet's copyright, the court first undertook the proper analysis of determining what, if any, of Overjet's UI, user interface here, is subject to copyright protection. And what Overjet was claiming was that the colors, the shading, and the shapes of their overlay was unique and creative and therefore worthy of copyright protection. However, the courts have to exert out any sort of functional aspects to those creative elements. So copyright is solely concerned with protecting creative elements. It does not protect and cannot protect any elements that are driven by functionality, that look that way because of the function that they were designed to perform. So as a part of the infringement analysis, the court has to look at these claimed elements and determine whether they are functional or whether they are expressive. And so first, the court looked at the shading of the different of the overlay, looked at the different colors: white for enamel, purple for pulp, and red for what Overjet termed problem areas, or the actual diseased areas. The court found that, first of all, the easy one is the white enamel, that white is functional for depicting enamel because enamel is white, and it is widely considered to be understood to be white, and therefore from patients to practitioners, depicting enamel as in a white color is a common sense and therefore functional choice to convey a type of information. Similarly, to not quite as easy, but to a similar extent, the court found that the use of red to depict problem areas was also a functional choice. The court looked at specifically Vidya's color scheme and saw that it had implemented a traditional stoplight type color scheme: green for clear or non-dangerous, non-threatening areas, yellow for potentially problematic areas, orange for serious conditions, and red for danger. And that type of stoplight color scheme has been widely recognized, widely implemented across all sorts of industries to convey a particular type of information. And so that color scheme, as applied here, even though Overjet was using slightly different shades of red, it was still depicting this traditional stoplight types color scheme, which is intended to convey information and therefore is functional in nature. So the white is functional because it accurately depicts the white enamel. The red is functional because it is a widely understood color scheme to depict danger or problematic areas. Similarly, green can be widely understood to depict non-threatening or non-dangerous pieces of information. And finally, the court looked to the overlay in the purple section. Overjet's is purple, they claim, because it works well with Overjet's branding and trademarks, whereas Vidya Health's depicts the pulp of the teeth in a slightly more bluish tone. Here, there was little discussion about the similarities between the two. Rather, the court simply said it's an obvious and functional choice to choose a color that has a significant contrast with the surrounding area. That contrast is itself intended to convey information to the practitioner, to the patients about the nature and severity of the cavities or the oral health. So the court took a look at all of these elements that Overjet had alleged were creative, and pretty quickly and with little challenge determined that all of them were functional in nature and therefore could not sustain a copyright, could not sustain an action for copyright infringement, and denied Overjet's request for a preliminary injunction. This is, I think, a fairly unsurprising case in the nature of how creativity and functionality has been applied to copyright, but is a new aspect in how these elements have been applied to AI type software, whereas the AI is developing the contours and the shapes of the imagery, but the choices here, the supposedly creative choices, are not created by AI. These choices were made by Overjet and NVIDIA employees and were for in some way either hard-coded or otherwise implemented so that the AI would not change how the at least the color and transparency of the different overlaid elements looked, but the AI dictated the contours, the shape of the problematic areas. Again, the court looked at the shapes that the AI had determined, analogized those to functionally representing the problematic areas and conveying that information, and found that those shapes were also functional in nature. But I think another aspect that the court could have dismissed of that shape contour is on the factual basis, because the software in this case is simply reading the tube composition and relaying that information. The contours of these problematic areas are not creative in nature. Rather, the AI is simply sensing it and relaying that information to the end user. So another way that the court could dispense of the shapes of these overlays as being creative is to focus in on the factual nature of the shape, and that there is no creativity either performed by humans or the AI in determining the shape of that overlay. So this case is, I think, a good reminder that the bounds of copyright protection are not endless, and that types of IP that are intended to protect expressive and ornamental designs, such as copyright, trade dress, and design patents, are limited to non-functional aspects of those features. And so both plaintiffs and defendants, copyright owners or intellectual property owners, and product makers need to be aware of the bounds of that type of intellectual property, and if they are looking to protect core functions that are functional in nature, that is squarely within the realm of utility patents. Please follow along with Rose Law Group for more artificial intelligence and intellectual property news for business that you can use.